But I'll now call 125-455 State versus Matthew Munoz.
May it please the court, Patrick Dunn, Deputy Appellate Defender, here today on behalf of Matthew Munoz. And again, may I please have 3 minutes? I think to put it as concisely as possible, this case is simply a case of unclean hands. I think the relevant timeline is pretty clear in this case. Mr. Munoz was in the Mitchell County Jail while simultaneously being held on a pending DOC warrant for post-release violations. He sends a letter that the district court, which gets filed on November 10th of 2020 in the middle of the pandemic, early in the pandemic, I guess you could say, saying, titled "A Motion for 180-Day Writ Callback," asking the court to begin the process to resolve his theft charges in McPherson County. Shortly thereafter, the then McPherson County attorney sends him a letter saying that he will be brought to dispose of that detainer after KDOC processes him. Then the following April, the state acknowledged the motion, files a motion for hearing. We have a first appearance on Zoom at the time. Mr. Munoz still in DOC. Then August 2nd of 2021 is a crucial deadline when this court reinstated the deadlines under the MDDA. And that was in 2021 PR 100. Then the final important date is April 11th of 2022 when he files his motion for continuance. After 252 days had elapsed. So we know at this point the state knew about the writ and it had sent Mr. Munoz a letter which any reasonable person would understand to mean that, yes, you've got this process that has begun.
Isn't the problem that your client never sent it to DOC?
Well,
And my follow-up is that uncontested?
first of all, there is no question that at the time that he sent the letter to the district court, the writ to the district court, that he did not notify DOC at that point in time. However, upon the state's questions during cross-examination, the state asked him, when you're in Mitchell County Jail, you didn't notify the Secretary of Corrections, is that right? And his response was, not when I was in the Mitchell County Jail, but when I got transferred, I did write your office. And I told the prison that I was on the writ or that I was trying to go on a writ. And I did keep everybody notified of everything every time I moved because I did move a lot, but I made sure I wrote every single time. And that was on volume 2, page 10. So it seems, yes, he did actually send notice to the Department of Corrections at some point in time. We don't know exactly when. And that was noticeably absent.
Is that a fact finding by the district court?
No, that was not in the district court's fact finding.
Fact finding was that he did not give notice to DOC, correct?
I don't know that it was that he did not, but he certainly did not at the time that he filed his motion, his writ. And we don't dispute that at all. We would contend, however, that it's that absent from prior proceedings was apparently no one had noticed this, that during the state's cross, that, yeah, there was actual evidence that he did do it at some point, which should have triggered DOC to send those certifications.
Right. And am I correct that
which brings us into Griffin.
Your primary argument, as I take it at least, is, look, he may not have notified DOC, but that doesn't matter in this case because he clearly did notify other agents of the state. And that's enough.
No, that's
Okay.
not enough. What makes the difference in this case is the concept of unclean hands. If he had just notified everyone, that's not enough. However, at the Griffin court, in Griffin, this court recognized that latches can still apply. And in Griffin, it was a situation where there was a 2-week break in between the time when Mr. Griffin sent his motion to the district court and the time, and he also notified DOC. DOC didn't send that certification for 2 weeks. However, that apparently he should have waited 2 more weeks before he filed his motion to dismiss, because that 2 weeks mattered in the timing of the 180 days. But in Griffin, this court said latches still applies. If DOC doesn't do what it's supposed to do in a reasonable amount of time, then latches would still apply.
Right. What's the unclean hands here?
There is no reason that the concept of unclean hands shouldn't apply to the state. When the state leads someone to believe that they have properly invoked the
So you're talking,
MDDA
you're
procedure.
talking about the correspondence back from the county attorney to your client.
Correct. If that had not existed, we'd be in a different case altogether.
So, okay, so I want to direct your attention to the statement in Griffin when we said, quote, when the inmate does what the UMDDA requires, statutory compliance may be excused. This is your notion of unclean hands. But it strikes me that that sentence, at least what I just read, suggests that compliance with the statute comes first. In other words, or I should say, the inmate's compliance. When the inmate does what the statute requires.
And he had begun to do what the statute requires. The statute has multiple.
Right. It addresses obligations to both defendants and state officials.
Correct. And he had begun to undertake those obligations.
But I thought you just admitted to me that he did not fulfill one of the crucial obligations.
One of
which
the
is to
obligations.
notify DOC.
Correct. And I'm acknowledging that. But the problem here is that the state led him to believe that he'd done everything correctly.
This is not a substantial compliance case. In other words, you're suggesting that just the equitable doctrine of unclean hands can apply in
We're saying-
general based on the letter that was received back, which therefore then prevented or deterred him from taking further action to comply with the statute.
We think unclean hands extends substantial compliance to taking any action under it. You don't have to get to the point of, in Griffin, it appears that the court kind of sets a bright line of, okay, the statute says you got to have the certifications when it starts the clock. That's what Griffin says. But this is a different situation than Griffin altogether. Because he initiated those proceedings. He began his compliance. And that was short-circuited. Had the state not said anything, we'd be in a very different situation too. Because under Griffin, he has this obligation to check to be sure things are going okay, is the way I read Griffin. But that changes when the state affirmatively leads him to believe that he has taken the action that he needs. What else are you supposed to believe when the county attorney says, okay, we've gotten your motion, your writ, and we are going to bring you back to undertake proceedings in this case. You'll be brought back after your process by DOC. No reasonable person would not interpret that. Or I guess that's too many double negatives. Any reasonable person would interpret, all reasonable people would interpret that to mean you've done everything correctly and the MDDA is underway. The 180-day clock is ticking. That's the problem, is he was misled by the state.
Is it is it that he was misled, or is it, and there may be no distinction here, but my question is it that he's misled, or that he just got a pro forma letter from the county attorney that they always send because they assume that the defendant would have followed the statutory requirements?
I don't see how it's pro forma when he says after your process by DOC.
I'm just
This was a
saying,
unique situation in as much as he was in the Mitchell County Jail under a DOC warrant based on his post-release violations, which I assume were premised upon both the McPherson County allegations and the Mitchell County allegations. So that wasn't a form letter he was sent. And unfortunately, we don't have that in the record, but it's,
Doesn't
we're
that,
talking, that's the state's job at that point, because the state was the one who lost this. Their job was to ensure that the record proves otherwise. We have to assume the district court made appropriate findings below. Clearly, the district court took this into account. The district court statement was, yeah, because the state tried to claim, oh, we didn't know what was going on with this. We didn't know it was we didn't know it was EMDDA. And the district court said, no, you did know in its order. It was clear. They didn't believe this. They didn't buy what the state was selling on that.
Wait,
And
when's the clock run then, under this unclean hands theory?
frankly, it should be at the time when the unclean hands take place. That's the obvious time for it to take place, which in this case doesn't matter because the real clock doesn't start because everything was suspended at that point in time. This is an easy case because the clock starts August 2nd, a year later. And the 252 days had passed after that point in time, well after the unclean hands took place.
How is that fair to DOC? I mean, it may not be okay with them that some county attorney is speaking for them.
It's
have
unclear to me,
obli-
it's
because
unclear to
they
me
have
what
to-
DOC's, I'm
Well,
sorry.
because they have duties here too. DOC has to, has certain obligations under the, MD.
DOC's obligations are ministerial. They don't have an interest in this. DOC's duties are to say how long the sentence is, what other cases you have pending, and how much good time you have, and then to send that on to district attorney. The district attorney is the one, if anyone, who would be quote unquote harmed or have an interest in this, because they could choose, well, we want to rush this and get this taken care of or not, because he has these other pending cases out there, or we need to take care of this sooner rather than later because under the changes of the MDDA in 2016, now it's clarified that if another case is picked up on a detainer action, then that doesn't keep the clock running in all the cases. All the cases don't run on 100 simultaneously on 180 days. But the point being, DOC doesn't have an interest in this. DOC's job is purely ministerial to provide information to the state.
But
They
what-
have no interest.
But what they do starts the clock, right?
What they do does start the clock, but the clock matters not to DOC, but to the state. And the state is the one that's obliged to follow the clock. And when the state leads someone to believe you've done things and the clock has started, they can't pull a bait and switch and then later say, oh, no, you didn't do it right.
Well,
That is fundamentally unfair. That's what unclean hands is all about. They weren't prejudiced by this in any way, shape, or form. The only person who was prejudiced, if anything, was Mr. Munoz.
earlier, though, you cited to the record that he later did notify DOC. Does that suggest that he did not then in fact rely on the letter he received from the prosecution? Why would, I mean, if his, it didn't induce him to sit on his hands.
No, presumably the reason he was notifying them was so they would know, hey, I'm going to be getting brought back to McPherson soon to resolve this. That's why I would interpret that. Not, I need to do more about this, but I'm going to get brought. Be sure anything coming from McPherson County comes to me. That's how I logically interpret that. Again, one thing I did want to touch on was the Court of Appeals that it was unclear when he exactly was served with the DOC warrant. And I briefly wanted to touch on that because that should have never been reached, discussed, or talked by the Court of Appeals. The question of when Mr. Munoz testified in the record that I was in at the same time on the DOC warrant and the Mitchell County charges. That right there is substantial competent evidence that he was under a DOC warrant at the time. Now,
Did he ever receive the warrant? Or does that?
he said he was under the warrant at the time. That's evidence right there that he did. If the state has a problem with this, when the time to bring this up was in the district court, because frequently, I don't know how many times we are told on appeal, you can't raise factual issues for the first time on appeal. And that's a simple question of fairness, because if there was a factual question, that should be raised in the district court because it can be addressed with more evidence at that point in time. If the state had a question as to when it happened, it should have raised that in the district court because this could easily be resolved. There was talk of Casper earlier. Guess what? If you look at Casper, that DOC warrant was issued in August of 2020, 3 months before this. So clearly that DOC warrant existed. Now, I understand that's not part of the record, but you know what? It could have been brought in the record had the state raised this at the district court level, which is
Has it-
why it is improper to raise it on appeal for the first time.
Anyone seen the warrant? Actual warrant?
Has anyone seen
Well,
it?
yeah, but was it ever produced?
I don't believe it came in below.
It's just has been testimony about the warrant. but its
Testimony-
its actual
testimony is
production
evidence.
has never been had.
Correct. Testimony is evidence, however,
No,
and
I
that
understand.
we're only looking at this
No,
point
I
at substantial
understand.
competent evidence.
I understand.
If the state had a quibble with it, the time to do that is not on appeal for the first time. Factual issues are resolved in the district court, not for the first time on appeal, which is exactly what the Court of Appeals did in this case, was said, we want to find out about this evidence for the first time on an appeal. Everyone proceeded below. No one ever said, and it was even pointed out during the argument in the closing argument by defense counsel, that the states never objected to any of this until, had never objected to the timing of anything. So given that that was the time to do it, it should never have been brought up now. There was substantial competent evidence based upon his simple testimony. That was the only other thing I wanted to be sure I touched upon. I'm going to try and let everyone get to a reasonable lunch hour at this point. Well, I can't promise anything on rebuttal. So if there's no other questions, let Mr. Obermeyer say.
May it please the court, the state appears by Stephen Obermeyer, Assistant Solicitor General. I tried to get Mr. Skeens with Blue Valley to stay to hear this argument. Had to go to see the legislature. I would like to address what was actually raised in the district court at the hearing on the motion to dismiss. And that was defense counsel citing an obsolete version of the MDDA statute, which stating the duty is on the jail officials to send the notice to McPherson County, to send a certificate to McPherson County. And it was argued several times, and it's in the state's brief of appellant, all the defendants saying that it was Mitchell County's job to notify McPherson County and do the certificate. That was the argument to the district court. And so on appeal, I write a brief saying the defendant was not in custody of the Secretary of Corrections. The statute doesn't even apply. The statute was amended substantially since the volume 2A. And so now my colleagues are arguing, oh, King's X, he was in custody of the Department of Corrections. That's why it wasn't considered, because it wasn't raised by the defendant in the district court. His argument was it was the jail's obligation to issue the certificate. And that's why I had argued that he should be judicially stopped from talking out of both sides of his mouth by arguing to the district court that the Mitchell County Jail's job was to issue the certificate. And now on appeals like, well, you know, the state didn't produce this, we don't know when he was arrested on the warrant. So now so he was in custody.
Is it your argument that the district court never actually made a fact finding on the custody question?
As far as DOC custody, yes. The district court never said that the defendant was in this custody of the Secretary of Corrections, the Department of Corrections at the time that was filed. The court just ruled that there was no action taken by KDOC, the Secretary, or otherwise being the jail officials of Mitchell County. They didn't do anything, and that's why the case gets dismissed. And now we're arguing that, oh yeah, he was in custody, and being a detainer, he was in custody in Mitchell County for I think it was a theft case from August to December when he was sentenced. At the time he filed his motion 180 writ callback, and I could do a Seinfeld bit about what is this? Is it a motion? Is it writ? But by the time he filed this, his case was still pending in Mitchell County. He had not been sentenced yet. So McPherson County can't drive out there, you know. We're here to get Matthew Munoz, take him to McPherson County. His case is still pending. What's going to happen at the sentencing date in Mitchell County? When he's not there, he's in McPherson County because he filed this, which mentions nothing about the MDDA, mentions nothing about final disposition and detainer. He just wants to begin the court process. If this case would be an example, what's the minimum I could put in something and have it qualify as an MDDA motion? This doesn't do it. And that's was one argument the Court of Appeals did not consider. And I asked this court to consider I cited a Colorado case, I think State versus Campbell, where you don't even mention the MDDA or final disposition or anything like that. And because when in 2016, when the legislature amended the MDDA, it put a trigger on when the prosecutor can worry about when the time starts to run. And that is when a person or any inmate in the custody of the Secretary of Corrections files a request for final disposition and gives notice of it to the county attorney charged and to the Secretary of Corrections, which was not done in this case as well. And so when the certificate does come from the Secretary of Corrections, then the prosecutor knows, okay, the time is running. And the prosecutor doesn't have to rely on every random jail mail that's received. And as far as what's the legal significance of this? Certainly the defendant wanted to begin the court process. This is a far cry from saying he was invoking the Mandatory Disposition of Detainer Act in doing so. In Ekus versus Dar, the defendant wasn't even aware that there was such a thing. I think.
Let's take a step back. Okay.
Okay.
The reason under the MDDA after 2016, the reason you send it to KDOC, okay, so the prosecutor doesn't have to worry about every allegation or whatever.
Right.
The reason you send it to the KDOC is so they can certify, okay, this guy's under KDOC custody. So they certify that and then they send it to the county attorney.
Yes.
Okay. And the reason just like you just said, that's so the county attorney is made aware the clock is ticking. Okay. And that's the purpose, right?
Yes, they can decide whether they want to, what kind of sentence is he serving? Is it worth bringing him to McPherson County on this step case?
But that happened here. Right? The county attorney was like, okay, we know. We're on notice.
We're on notice.
And here we're sending you a letter saying, okay, we're aware and we've made our plan. Our plan is as soon as you, get convicted or whatever and actually get transferred to a facility that is run by KDOC, even though you're being held, then we'll do it then. So the whole purpose of the statute was satisfied, right?
Justice Standridge, I don't think that, I think wanting to be brought back for trial, which the prosecutor said, we'll bring you back, and wanting to be brought back for trial under the MDDA are two different things. And not every, request to be brought back means it's under the act. And the statute was amended to require notice to the Secretary of Corrections so they can calculate this. And the certificate is what triggers the prosecution or the prosecutor to decide whether to bring them back. And by the way, he was brought back the day after this court set aside COVID in August of 2021. He has a prelim in August of 2021. He's got a pretrial in November of 2021. says nothing about, hey, what about my mandatory disposition of detainer? Especially when it gets set beyond his perceived 180 days. The court's going through an analysis as far as speedy trial under the speedy trial statute, as far as setting it for trial. So he can just say nothing about it until.
You could argue the reason that they brought him back the day after was because they were aware.
Well, because they were aware of the MDDA.
Yeah.
I don't, think the prosecutor has to do a mind meld of Matthew Munoz and see what his
Well, the
intent was.
prosecutor knew, right?
He wanted to be brought back.
Well, I
Yes.
don't really think that the defendant would have an obligation to tell the court and the state that the clock is ticking against the state. But my question is, do you agree with Mr. Dunn that the DOC really doesn't have a dog in this fight, and they don't really care whether the county attorney speaks for them?
I would think the DOC would not want the county attorney speaking for them, that there's a case on acquiescence. The state can't acquiesce or confer jurisdiction on the case. It's the DOC that prepares the time served, time remaining, good time credit, and issues the certificate. So I think that's more than a ministerial role, that you're putting the prosecution on notice that there's a request for disposition of detainer under the act. Not just that he wants to be brought back, but under the mandatory disposition of detainer act. So I think it is more than just a ministerial role, and the prosecutor can't waive that or acquiesce. The parties can't confer jurisdiction to say that the act.
So does you agree that DOC has independent duties under the MDDA?
Yes, and it's set out in 4302 as far as what they have to do, and they were not notified of this. And so that's why we're even at the unclean hands argument. And I did cite some cases on unclean hands, and it involves something, inequitable conduct by one party. And I don't think, here it is. A litigant may be denied relief by a court of equity on the ground his conduct has been inequitable, unfair, and dishonest, or fraudulent and deceitful as to the controversy and issue. And that's Gobin versus Berry. The district court never found that the county attorney Benefiel engaged in any wrongdoing or inequitable or unfair or dishonest, fraudulent, deceitful misconduct. The letter did not say that the county attorney's office intuited that Munoz was aware of the act, opined that he was trying to invoke the act, and affirmed he had complied with the act's requirements. It merely said, this has been filed, and you'd be brought back.
And we've applied equity principles in this context, but it seems to me it's been where there's been substantial compliance with the act, but due to no fault of the defendant, there were delays created by third parties. Here, it's a different situation. Seems like we're expanding it to excuse substantial compliance with the statute. And what's the distinction? And what would prevent us from going to making that next leap, I guess?
Well, I think the Griffin case says that it's more than without clear proof of wrongdoing by the officials, the inmate has not effectively shifted the burden. And Griffin says that you at first have to comply with the act before we're going to start assessing blame as to whose fault it is. And the language in Griffin, we're talking about officials. I think we're talking about prison officials, the Department of Corrections, not the prosecutors for sending a letter saying we got your writ. So I think Griffin is the most recent pronouncement on what must be done under the act. and it was certainly after the legislative amendments in 2016. The defendant has to inform the secretary, and the secretary never sent registered certified mail along with the certificate to the court and county attorney, which starts everything. And there was no clear proof of wrongdoing in this case. And I don't think you should change what Griffin requires as far as misconduct or unclean hands or whatever you want to call that.
Counsel, can I take you back real quick to your judicial estoppel argument?
Sure.
Earlier on in your argument, we had a short discussion about whether there was a fact finding below. And I went ahead and looked, and at least as I read the record, it looks to me like the district court did make a fact finding that Mr. Munoz was in KDOC custody. Does that change your approach to the judicial estoppel argument?
No. And if you're citing volume 2, page 23.
Yeah, that's what I'm looking at.
Okay. The court says, the state knew that actual notice of Mr. Munoz's intent to dispose of this detainer while he was in KDOC custody, and therefore this filed under substantial compliance with actual notice to the state. I don't know if that's a reference to the prosecutor's letter, or the fact that when he's in KDOC custody, that he would have to notify them. Let's see, intent to dispose of this detainer while he was in KDOC. I don't think that's a finding that he was in KDOC custody, because in the cases I cited, I think in this reply to the petition for review, you can't, if there's a detainer on you, you can't be arrested on the detainer. It's
Right, but the defendant's whole argument at the hearing, and he testified to this, is that he was under a warrant.
well,
The evidence was there, even though the warrant wasn't.
I disagree with that, Justice Deagle. As to a KDOC warrant, he testified, he was asked a question like, when was the KDOC warrant served on you? And his answer was, I filed the writ when McPherson County sent me the warrant. It was a non sequitur as far as that. And that's what the Court of Appeals pointed out in the opinion.
You may be right on the merits of the evidence. I'm just trying to work through this whole estoppel argument.
Right.
And it strikes me that if a party below, through faulty legal argument, makes it so that district court doesn't make a fact finding that's necessary, judicial estoppel would suggest you can't turn around on appeal and blame the lower court. It's almost like invited error. It's a similar kind of concept. But here, I just don't see how you can make that claim when arguably, at least, the district court does make the fact finding. How are they stopped from arguing against a finding that the district court actually made?
Well, there was no evidence that he was in KDOC.
I know that's on the
custody.
merits, like the evidentiary question's on the merits. I'm focused on the estoppel part of it.
In the next paragraph, the judge says there was no action by the KDOC, the secretary, or otherwise, or the state reaching out. I think that or otherwise language is the judge saying Mitchell County was responsible, as the defendant had argued to him, that Mitchell County was supposed to do the certificate because that's the way it could have been interpreted prior to the 2016 amendments. But there was no evidence of that. And State v. Nicholson, and it's in, I think, the reply to a petition for review, says a person already in custody cannot be arrested on an outstanding warrant from another county or jurisdiction. Because it gets to, hey, can McPherson County or KDOC say, hey, we're here to arrest your guy from the Mitchell, from the, what county is he in?
McPherson?
Well, McPherson going to Mitchell County, we're here to arrest him, to, take him to trial. And KDOC can't say, we're here to arrest him on our detainer. A detainer is just, let us know when he gets out, when he finishes, because we've got dibs on him or we want to consider whether to bring him back. That's way different from saying that he's in custody on the KDOC warrant, or that he's in custody on the warrant from McPherson County. A person already in custody cannot be arrested on an outstanding warrant from another county or jurisdiction.
Well, this was a probation violation, right?
No, this was a theft charge that was filed, I think in September of,
Okay.
2020. And by the way, the hearing on the motion to dismiss was in July of 2022. There's,
Okay.
a 2 or 5 year statute of limitation in criminal cases. This was all considered and done before that had even run. So it was pretty fast, especially once the once this court issued the order that we're resuming trials. So I see that I'm out of time, but I would refer the court to the last couple of pages of your opinion in Griffin, as far as the duties on the defendant, what the defendant has to do before it even triggers, what the Department of Corrections has to do. And this was not misconduct by the prosecutor sending a letter advising that it had been filed. And I don't think Mr. Munoz should be rewarded for misarguing that the MDDA applied to the Mitchell County Jail. So I think I agree with what the Court of Appeals put in its decision, and would ask you to affirm that. Thank you.
Frankly, I don't think the state should get to benefit from misleading clients. I think that's where the real problem is here. First, I wanted to turn quickly to the judicial estoppel. And I fully agree, there was nothing inconsistent here. We had factual finding. He even pointed out in his motion to dismiss that he was being held on a detainer at the Department of Corrections. The state somehow is trying to make an argument that a detainer is not the same as custody. Burnett, I think, says otherwise. Burnett says custody contemplates an intent on the part of prisoners officials to exercise actual constructive control of the prisoner, and that in some manner the prisoner's liberty is restrained. I think that falls squarely under. But even more importantly, if we go back to speedy trial cases, and we know from regular statutory speedy trial that if you are in custody on something other than the pending cases you're arguing speedy trial in, then that speedy trial doesn't apply. Yet in State v. Hill, 257 Can 774, this court said, well, he had a DOC detainer, so he wasn't in custody solely on the pending charges. So this court has recognized that DOC warrants constitute custody. So there is no real argument here that it's not a real thing.
So I want to shift you to what I take to be your primary argument on unclean hands in the time you have left. And I want to hear your best argument. And I'm going to quote here from the language this court has used in Sweat and Griffin. What's your best argument that the letter from the county attorney was, quote, affirmative wrongdoing intended to thwart the inmate's request by misfeasance or malfeasance?
When you say, let's just make it even simpler. If the letter had said, we know from the district court's factual finding that the district court found, we can't do the state's Key Rock, SNL, Phil Hartman. We didn't know what this was. Your ways confuse me. District court found that they knew this motion for a writ was an attempt to invoke the MDDA. So given that, if we can make it simple, the letter says, we have received your motion to resolve your pending detainer in McPherson County per KSA 224301 et sec. We have received this and are proceeding accordingly. You will be brought to for further proceedings under KSA 224301 et sec following your processing with the Kansas Department of Corrections.
How is that affirmative wrongdoing intended to thwart the inmate's request?
Because the inmate requested to be, what is the inmate's request? under the MDDA. The inmate's request is, I want to be tried within 180 days. That's what the
So this
the
letter
MDDA
that
is.
in the county attorney's head, I mean, what you're alleging is that the county attorney essentially wrote this letter as an affirmative attempt to undermine this request.
That's exactly what I'm saying. Otherwise, we have to take effect to it. The state can't sandbag this sort of thing and say, oh, no, it's not now. That is really, it thwarts the entire purpose of the MDDA, which is to have a resolution of these pending charges so that there's no uncertainty out there. That absolutely thwarts it. If the state can send a letter like this to, what if that is the case, why would the state not in every case send out that letter?
Well, I was suggesting they probably do, because if in fact the inmate had complied with his statutory obligations, there would be nothing at all wrong with this letter.
The problem is that this letter misleads a defendant into
And I
believing
wanted
they
to-
did.
I wanted to grant that, but I think that the legal standard for unclean hands is higher than a simple misleading or misunderstanding. And again, that's why I just wanted to hear your best argument for how this is an affirmative wrongdoing that intentionally thwarts the inmate's request.
I think that if upon that, well, if we want to move further along to the actions of the subsequent county attorney, which clearly took place sometime after January 3rd of 2022. And I know this, we can say this because the final journal entry submitted by Mr. Benefiel was, I believe, of a pretrial hearing that was filed on January 3rd. Subsequently, we have an acting county attorney, and then we have the attorney who handled this, Mr. Perkins, filing everything. If at that point they believe something was wrong, then they had a duty to remediate what the affirmative misleading was before. That certainly is unclean hands at that point too, if they believed otherwise, because they knew he wanted to get this done as quickly as possible.
Essentially, you're suggesting that letter can't go out until really the certification is received back from DOC.
Yeah, if you truly believe, it ought to mean what it says. You ought to be able to rely on it. I think that is what latches and unclean hands are all about. You can't mislead someone like that to their detriment. And there's no question he would be prejudiced, because the Court of Appeals found there was certainly, that if we reverse this, that certainly prejudices him. And the final thing I wanted to touch on was, again, Mr. Obermeyer and Your Honor, turning back to 4302, of course, the state was claiming that, no, it's not ministerial at all. The actions required under 224302 are to certify the term of commitment, time already served, time remaining to be served, good time earned, time parole eligibility, and any parole board things. Certify any good time for crimes after any guideline sentences. And finally, to send via registered or certified mail a copy of the request and certificate to the county attorney. That is literally ministerial. Now, what interest could the DOC possibly have? Under Griffin, they have to promptly do this. They don't get to decide, we're going to put this off, are we going to do it? Are we not going to do it? There is no, this is like a computer program. It is as definitionally, literally ministerial as it comes. It is purely a ministerial act. So they don't have an interest. DOC is in no way harmed. The only party at issue is the state. And the district court found the state was fully aware of what was going on. That was a factual finding made below. Finally,
You don't think that DOC is going to be blamed privately and maybe publicly if they don't do that certification in a timely manner?
well, if they don't do it in a timely manner, then the defendant wins under
Does-
Griffin.
Right,
That's
doesn't
what we
that
say
give them a
there.
due process right to be notified?
I'm sorry.
Doesn't that give them?
They don't
the-
get a right to be.
Well, they are supposed to be notified under the statute. That's what triggers their obligation to do a certificate.
Certainly. In this situation, they have no obligations. There is no harm to DOC here. To be a party with an interest, there has to be some kind of harm that could come to you or some kind of benefit. There is no harm or benefit in this situation to DOC. So therefore, they're not really a party of interest. They are purely ministerial. That's where certainly the county attorney might try and blame it on them later because they're a political actor and they're elected and they want to win their election and they want to deflect on why they misled, why a case might have been reversed because they took actions that misled a defendant. Sure, they might want to blame somebody for that, but that's a political question there. That doesn't have to do with legally whether it's ministerial or not.
Well, there's no allegation that they received notice, is there? There's no evidence that they received notice.
Well, there was, again, I point out there wasn't a finding on that, but there was evidence in the record in as much as in response to the county attorney's questions on cross-examination, he informed the Department of Corrections that he had filed or was attempting to get filed
Right, but there was no.
under the MDD. He did not produce there was not paper documentation on that, but there was testimony on that. And that was in direct response to the state's cross-examination.
Okay, just to clarify, there was evidence, but no finding.
Yeah, there was no finding on that. I will fully concede there was no finding on that because no one took that at issue. District court proceeded as though it wasn't. But again, I don't think I think we're still, ultimately it comes down, this case is an unclean hands case. I think that's what this whole case hinges on. And again, we don't think the state should be rewarded for misleading defendants when it directly thwarts the purpose of the MDDA. No further questions. I would ask that this court affirm the district court and reverse the Court of Appeals.
To both parties for your arguments today. The court will take this matter under advisement.